Hey guys, what's up? So let us discuss today a very important topic. Many people were asking about contempt of court and what is contempt of court. So it means that the first thing which we need to understand is that justice should not only be done but also seen to be done. People should perceive that they are justice being done, and this is the golden rule that maintains the faith of the people in the judiciary. The aggrieved party or the victim, whoever he or she may be, and the accused, that is the person who is accused, both should have full faith in the judiciary, otherwise, the system will collapse. Now, contempt proceedings are another domain which has been really controversial, and it has its ardent supporters who believe that it is necessary to ensure the functioning of the courts without undue extraneous influence and public pressure. Okay, so there are people who support it. The opponents says that it should have no or very limited law, because in a modern democracy where we are emphasizing on freedom of speech and expression, it should not be there. So that is opponents, what the opponent says. So creation of a balance in its application has always been a debate. इस पे काफ़ी डिबेट चलती रहती है, एंड द सो एनी डिमांड टू कोडिफाई इट, जब भी कोडिफिकेशन की बात होती है, सो द कोर्ट सेज दैट it will limit the court's power to ensure its superiority and punish anyone which will cast undue and uncalled for aspersions on its impartiality and integrity. Anybody who questions the integrity of the court shall be punished. So it does not warrant it to be codified. So as it is understood today, so contempt of court is the offense of being disobedient to or disrespectful towards a court of law. I know it is very vague, but that is what it is. You can't do anything about it. And it will include like being disrespectful to the legal authorities in the courtroom, or willfully failing to obey a court order, tampering with holding evidence, interruption of proceedings. All may attract contempt of court proceedings, and it is any behavior or wrongdoing that conflicts with or challenges the authority, integrity, superiority of the court. And a judge, if he finds that you are in the contempt of the court, he or she may impose sanctions like fine, jail. Okay, and a caveat or exception here is that the judgment of the court may be criticized. Listen to it carefully. But no one can criticize a judge personally and accuse any judge of partiality and bias or lack of integrity. Example, the criticism of the Supreme Court on the section 377 may be justified, but one cannot criticize individual judge as being homophobic or anti-homosexual. So what is the purpose of the law of contempt? So civil society is founded in the respect for the law, and if there is no respect for the law, if everyone chooses to break the law, there cannot be any civil society. And it is this respect for the law and the law enforcing agencies that somewhat ensures that freedom recognized in the constitution. So I hope the introduction is clear. So now let us see about the provisions of it. So Article 129 and Article 215 of the Constitution of India empowers courts for the contempt. Now Article 129 says that empowers the Supreme Court. So 129 deals with Supreme Court, 215 deals with High Court to punish people for their respective contempt. Now high courts have been given special powers to punish contempt of subordinate courts also. So there is no separate provisions for subordinate courts. As per section 10 of the Contempt of Courts Act of 1971, high courts have the power to punish contempt of subordinate courts. Now it is a very important power, since the subordinate judiciary, it is the most vulnerable to criticism and undue influences. Usually people will not criticize Supreme Court and High Court. So Contempt of Court Act of 1971, it defines the contempt into two categories. One is the civil contempt and other is the criminal contempt. Now in India, civil contempt is willful disobedience to any judgment, decree, direction, order, writ or other process of a court, or willful breach of an undertaking given to a court. So this is the civil contempt. Now criminal contempt is different. Criminal contempt has been defined as the publication, whether by words, spoken or written, or by signs or by visible representation or otherwise, of any matter or the doing of any other act whatsoever, which can either lower or tend to lower the authority of any court, interferes or tend to interfere with the due course of any judicial proceeding, obstructs or tend to obstruct the administration of justice in any other manner, and the jurisdiction regarding contempt is a special jurisdiction. So it must be used to uphold the dignity of the courts and the majesty of the law, to keep the administration of justice unpolluted. So it is basically to have the faith of the people unshattered in the judiciary. The power of contempt is often invoked to ensure the compliance with the orders which are given by the courts and in their execution, and for punishing those who are responsible for the lapses in the manner of compliance. So this is also important. And further, the availability of the contempt jurisdiction provides efficacy to the functioning of judicial forum, and it will also enable the enforcement of the orders on account of its deterrence effects on avoidance. So this is entirely about the Act of 1971, which defines civil contempt and criminal contempt. Now let us see the cases which are connected with the contempt of court in India. So these are the important court cases. So many cases in which Supreme Court or High Court, they have a lot of judgment on observation on contempt of court. They include, first is Vinay Chandra Mishra of 1995. So the Honorable Supreme Court reiterated that the position of law relating to the powers of contempt and opined that the judiciary is not only the guardian of the rule of law. And so in this case what happened was, Vinay Chandra Mishra, he shouted on the judges, and he was prima facie there was found a case against him, and Supreme Court said that it has huge powers when it comes to contempt of court, but it is not like exceptionally large also, and it cannot involve the advocate also who is supporting him, and so on and so forth. Then there is a case by P.N. Duda versus V.P. Shivshankar and others in 1988. Supreme Court observed that the contempt proceeding should not be used by judges to uphold their own dignity. It is rather the court. And in the free market places of ideas, criticism about the judicial system or the judges should be welcomed, so long as the criticism do not impair or hamper the administration of justice. So here the court is saying that you can criticize us, but as long as the administration of justice is not hindered. Then third is the Arundhati Roy case. You might be like, you know her, that she is an author. The Supreme Court observed that the fair criticism of the conduct of a judge, the institution of the judiciary, and its functioning may not amount to contempt if it is made in good faith and in public interest. So fair criticism is allowed, but unfair criticism is not allowed. So these are the three major cases. Now the crux is that freedom of speech and expression versus contempt of court. So Article 19(1)(a) of the Constitution gives the right to freedom of speech and expression to all the citizens. But Article 129 and 219 limits the power of freedom by saying that contempt of court should not be done. Now Justice Krishna Iyer says that law of contempt has a vague and wandering jurisdiction with uncertain boundaries, like the justice himself is criticizing it, and such a law, regardless of public good, may unwittingly trample upon civil liberties. Enforced silence in the name of preserving the dignity of the judiciary would cause resentment, suspicion. That is like the justice words himself. And in a democracy, the people should have the right to criticize judges, and the purpose of the contempt power should not be to uphold the majesty and the dignity of the court, but just to enable its functioning. And the rights of citizens should be treated as primary, and the power of contempt should be subordinate to it. But right now it is not that way. So what is the relevance of contempt law in the free modern society of today's world? So the power to punish for contempt was draconian in nature when it was evolved, and without having safeguards in favor of the persons charged with the accusation of having committed contempt of court. The First Amendment to the US Constitution forbids imposition of contempt sanction on a newspaper. So they are saying that newspapers are free to publish. And the concept of criminal contempt in India, because its origins to the mid-British times, was a corollary of the adage that the king could do no wrong. So it is from that times. And in a free society, criticism of the judiciary is inevitable. Everybody will make mistakes. And just as decisions of other branches of government, like executive, तो आप रोज ही कुछ ना कुछ करते रहते हो, and legislative also undergoes criticism. Similarly, judicial decisions would also invite the same. So what is the way forward? So the law of contempt should be employed only to enable the court to function and not to prevent criticism. And the basic principle in a democracy is that people are supreme, and once this concept of popular sovereignty is kept firmly in mind, it obviously becomes that the people of India are the masters, and all the authorities, which include the courts, are their servants. So this is unavoidable. People of India are the masters, and everybody else is servants. Now it's time for legislature to take steps to amend the Contempt of Court Act and define criminal contempt properly. And judiciary should also balance two conflicting principles versus, that is, the freedom of expression and fair and fearless justice. So I hope the concept is clear now. Thank you for watching this. Have an awesome day.